focus on Liberia. From Cape Mount to Cape Palmer, mountain back to Atlantic Ocean, Obomi Hills to Pocondre, to educate, elevate, and promote. Yeah, focus on Liberia. For Liberia, Liberia. For Liberia, yeah. From Monday to Sunday. From Monday to Sunday. It's focus on Liberia. Talk about home affairs. Hey. In diaspora. Foreign affairs. Reliable information. History. Talking about culture. Politics. Education. Entertainment. Business. Sports. Advertisement. Articulation. Focus on Liberia. Focus on Liberia. Focus on Liberia. From Monday to Sunday. Focus.
Hello, ladies and gentlemen, and welcome to FOL Justice Forum on Focus on Liberia. My name is Dennis Jayweh, and we're broadcasting from Atlanta, Georgia. In tonight's edition of FOL Justice Forum, we're going to be talking about the indictment of Finda Bundoo, Thelma Sawyer, and 40 others for money laundering. That's the case in Monrovia, in Liberia, and we have a team of lawyers to break it all down. Let me welcome FOL legal analyst, Councillor Frederick Jayweh. Welcome, Councillor.
Thank you, Dennis. I'm happy to be here.
Thank you, Councillor Jayweh. How are we doing in Colorado?
Well, Colorado is fine. The weather is dropping, but it's not that cold yet.
Thank you. Let me also welcome Attorney Wonderr Freeman. He's an attorney, of course, an economist, and also a financial crimes expert. Welcome, Attorney Freeman.
Thank you, Giros. Very happy to be here.
Good. And how's Minnesota and how is the NPR movement?
Well, Minnesota is good, and the NPR movement is working behind the scenes for now. But we have a lot of things we're going to come up with early 2026. So it's going to. So we're kind of putting plans to action now.
Thank you. We're happy to have you. We're happy to have you. Also, we have the CEO of 2A Communications, Attorney Jensen. He's always gracious to be here whenever we call upon him. Attorney Jensen, welcome.
Thank you so much. It's a pleasure to be with you guys tonight, and I hope we'll have a fruitful discussion. Yeah.
Thank you. We want to welcome all our viewers from across the globe. This is focused on Liberia, where we educate, we elevate, and promote all things Liberia. If you have not done so already, please share the show, invite someone, and let's get started. So we have the indictment of Finda Bundoo. So I will ask one of the, but the case is like this. I was fortunate to have the indictment. And so they have Finda Bundoo, the former deputy minister, chief of protocol under the Jayweh administration, Francis T. Blambo, manager, Gracious Rai, and Anita Jala, chief executive officer, and on and on and on. Thelma E. Duncan Sawyer, deputy minister of administration, Ministry of Foreign Affairs, and others. Okay, all the way, I think they're around 40 or 42 persons. And what are they arrested? So they order the arrest. They say you are hereby commanded to arrest the living bodies of the above named defendants in the above entitled case of action charged with the commission of the above mentioned crime. And what is the crime? They listed all of them, and the read reads. They listed them: Anita Business Center, Thelma Sawyer, Deputy Minister of Administration, and others be identified did conspire, connive, facilitate, and did commit the crime of money laundering in flagrant violation of 4 Cllr Title 26, Section 15.2.1 A, B, C, and F. And if you go through the indictment, you will see it said Finda Bundoo 26 accounts, and then you will see money moving from one person to the other, being the U.S. and so on and so forth. That's what we're going to be talking about today. But you know, they say not because they no matter how long the storm stay under the water, it can turn into a fish. So no matter how long I talk with lawyers, I can be a lawyer because I'm not. So let me go to the lawyers now to just give us a synopsis of the case of the indictment. And I'll start with Attorney Freeman.
From the indictment, Finda Bundoo and others were charged with money laundering, criminal conspiracy, criminal facilitation, theft of property, and forgery. And a lot of emphasis, it seems to me, was placed on the fact that she was poor and penniless, and that subsequently, when she entered government, she got wealthy and started transacting to the tune of $6 million US, close to $7 million in fact, and 800 million Liberian dollars. So I guess other people will come in to say what their opinions are, but normally for money laundering, you really have to prove it in conjunction with other crimes. And mostly those crimes have to be established first before you establish the money laundering crime. So, for example, you could say somebody committed bribery, they got money, and then they launder the bribery money. Or somebody committed armed robbery, they got money, they launder the armed robbery money, or drug dealing. It's always tied to another crime. So in this case, you will assume that because theft of property was included, most likely they are alleging that she stole the money. But I don't want to jump the gun. Let me see what other people say, whether they...
Don't jump the gun. Explain to all when they say money laundering, what does that mean?
Okay. Under Liberian law, and for the most part, because money laundering laws are generally all coming from this UN Convention on Corruption, so they are very similar. It starts with you taking the proceeds of crime. And by proceeds of crime, that's what I mean. If somebody bribe you, bribe is a crime. When you take the bribe money and now try to maybe put it into a business enterprise or pass it off as some legitimate income, then that's the laundering. But you can't have money laundering unless there is a prior crime was generated. A prior crime was committed. That prior crime produced money. And that money now is being invested into legitimate businesses or operations to give the impression that it came from honest work, whereby it came from crime. So that's the money laundering. So there is no such thing as money laundering if you don't establish that a previous crime was committed and money came from that previous crime. Is that clear on it?
Councillor Jayweh, very clear. And I hope my Councillor Jayweh, they have money laundering, theft of property, misuse of public money, property records, criminal conspiracy, forgery, and criminal facilitation. Those are all big words. I want you and Attorney Jensen to break them down for us one at a time.
So let me just comment on the way charges are made in Liberia. The Ministry of Justice in Liberia, in conjunction with the grand jury, can get an indictment, a true bill they refer to, and list several crimes that the state contend that defendant or defendants, in the case of Finda Bundoo and others, are alleged to have committed. So they have been listing a lot of crimes in conjunction with theft of property. And therefore, the way the trial, the process that the trial takes in Liberia, I think most of the charges, what I have seen, appear to be improperly made. I say that to say that what I've seen the state been doing is pick a lot of charges, hoping that one or two of those charges will stick. But under the criminal procedural law, I wouldn't want to go further, but under criminal procedural law, an accused has the right to notice. In other words, what is it that Finda Bundoo and others are charged with? Money laundering is one of the counts they have in there. I guess what they're also saying is that state money was stolen, and then Finda Bundoo and others tried to pass it through the system to make it to look like this is a legitimate investment into properties and other things. So stealing money from government, using it to buy property, renting the property out, opening bank account, putting the money in there back and forth would be considered money laundering. But the basis will first be that theft of property was committed. Something was stolen. And that thing that was stolen may be government revenue and resources and being used to be able to try to legitimize ownership of properties that Finda Bundoo and others, the 40 or 42 defendants might have committed in Liberia. So money laundering as well as theft of property, misuse of government public fund, criminal conspiracy, those are all first degree felony. I have said, and I don't agree with the way charges are being drawn by the state. It's like you're guessing, hoping that something may stick. And at the end of the day, if the defendants are convicted of theft of property, then the government wins. That's how it looks like to me. And also, my core is that the defense counsels have not done well to be able to challenge how those indictments are drawn and served. They just basically jump into the courtroom and begin to have trials. And so nothing substantial goes on, which is much more salient to the defendant knowing the requirement for notice is not certified. So the defendant just go through a trial. If he or she is convicted of money laundering, theft of property, then that's it. But that is an improper way of charging.
Thank you. Attorney Jensen.
Thank you, guys. It's a pleasure once again to join all of you guys. And yes, the facts of this case can be summed up to the point where Nura Finda Bundoo, former Deputy Minister and Chief of Protocol, her daughter Anita Pamela Jala, and others have been charged with money laundering, theft of property, and illicit enrichment. I will sum all of the charges to these three. And like Councillor Jayweh said, it seems to be a common strategy among lawyers in Liberia. Always you want to throw the net so that if you miss probably one big catfish, you will get something on the other side. But I think if there are good research and you have the facts very well, and you can ask the right question to be able to make perfect analysis to prove your case, there's no need to grab a whole lot of charges and put it on the docket or to charge a defendant. But the strategy has been employed, in my view, it's left with the lawyers to prove whether or not Finda Bundoo, the daughter, and the other individuals charged can be found guilty. To prove money laundering, there are a few elements that we hope that the government will be able to prove. Like, was there a financial transaction, okay, that occurred in Finda Bundoo's Finda Bundoo's daughter and others, to which the government has decided to charge them? Well, I'm sure it's easy to prove that Finda Bundoo has several financial transactions. But the second point would be, were there illicit financial transactions? Were there wrongful financial transactions? By this time, we are hoping that the grand jury, in their true bill, saw some, probably some of these pieces of transaction, deposit being made, money being transferred from one bank to another. So all the pieces of information, it is believed that the grand jury truthfully have seen these pieces of document, to which they are convinced that Finda Bundoo, the daughter, and others can be found guilty. Now, this is still an allegation, but the grand jury themselves, they are proving to they are proving on the record, indeed from their investigation or from the fact finding, they have come to the point to agree that these individuals actually committed money laundering, theft of property, and illicit enrichment. My concern further goes to the point, Finda Bundoo was not just an ordinary person in the U.S. government. She occupied a very key position in the office of the president. So, and she was handling, if I'm not mistaken, a lot of financial transactions. This, in my view, should even go beyond the court. There must have been a very sufficient way of investigating this matter, because whatever we say here, this transaction will border the office of the president, because the office of the president, there's always financial record or request being made to the Minister of Finance. So
Right.
all of these transactions to which the finance minister himself before release. So Finda Bundoo is just like
And we'll come to that detail. I want us to I want to end with this, right? Because for those of us who are not
but Dennis, to a point of correction, read the charges, because I think there is a charge that he's naming that is not there.
like
okay.
You said illicit enrichment.
mhm.
Look at page 1
Well,
of the indictment. Read the charges,
listen to me,
Dennis.
this is what I said. Yeah, let me provide
No,
more
not
to that.
Dennis, read the charges.
Yeah. Okay. So
No, it's not-
enlisting
it's not-
enrichment is not there. So before we even will get to the charges again, but when they say grand jury, the indictment, what happened? Those of us who are not lawyers, when we hear grand jury, we looking at the trial. So the indictment at grand jury, but just walk us through how the indictments are, brought. How was this?
So-
what's the process? Just end with
So
that.
let me walk you through the process.
Okay.
The grand jury process is not a trial process. The only people who, or the only lawyers who go into the grand jury section is the Minister of Justice, the prosecutors, maybe the county attorney, people who handle this particular case. We go with a series of complaint and evidence that they think they have, pieces of evidence that they think they have, and present it before it could be 12, it could be 14, it could be even 16. I think the law has changed on how many jurors now sit in there. And then try to convince those men and women who are sitting in a special section to hear the facts concerning, let's say, the Finda Bundoo case. The state will go and try to convince the grand jury and say that, look, a crime was committed here. Finda Bundoo and the other 40 or 42 people joined together to rob the government of Liberia. He will present, or they will present, the evidence they think they have and try to convince the grand jury to ensure that the grand jury will say, okay, we think there is a probable cause here that a crime was committed. All of this section, all of what happening before the grand jury, the no defense counsel is there. It's just a state and group of people in one room, the state discussing the complaint, what they think the crime is all about, and what the law supporting the state position is. And the grand jury will end up voting, the group of people will end up voting to say that, oh, there's a crime, there's a probability that a crime was committed here. So we will agree that we can charge, draw up, fine, something called a true bill, agreeing with the state that we think that a crime was committed here. And so an indictment is proper to be issued. So from that true bill, and all of this happening with just the state and the group of people in that room. So the indictment, if it is drawn, if the grand jury all voted and said that, look, we see a reason for which a criminal case should be brought here, they will vote and will agree that a criminal case is brought. The state will end up completing the technical process of drawing on what they call an indictment, which is a bunch of allegations, as you see laid out in the indictment you're seeing there. And then they will bring it out of they will be brought and filed with the clerk. And the judge may, after reading the indictment, the judge may order the clerk to issue a writ of arrest. But all of this is happening with the state and government lawyers. No different lawyers in that process at all. So that is not a trial process. That's a process that the state is trying to bring a case against a group of defendants.
Thank you. So let's go back. The crime, money laundering, theft of property, misuse of public money, property or records, criminal conspiracy, forgery, and criminal facilitation. Let me ask you all, what evidence will be needed to prove these things? You can pick one, starting with here. What would
let me go first, because I really think that there is no case in this thing. So let me go first.
Okay.
This is not about lawyering. Theft is very easy. You take property that don't belong to you, it belongs to another person, another institution. And you take it and possess it and try to use it for yourself as your property or stuff like that. It doesn't belong to you. You take it. That's theft. It could be services, but you have to take something that don't belong to you. Okay? So they are supposed to prove that one, Finda stole money. Two, the money didn't belong to her. Three, this is how she stole it. This is where she stole it. This is how much she stole. And then that will be the theft of property. Then you establish that. Then the money that she got now, that stolen money, as she put it into real estate and other kinds of businesses and try to make it look like our own money, then that would be the money laundering angle to it. But look at the indictment. I can send you to count 86 to 90. Look there. There is nothing about which institution she stole it from, where she stole this money, how much she stole, when and where, how the stealing occurred, how much was stolen, nothing. He just focused on the fact that this lady was poor, and then all of a sudden she started spending money. So she must have done money laundering. That is an amateurish perception of what money laundering is. You must start with a process of crime. There is no money laundering if you don't have a process of crime. And for you to have a process of crime, there must be a previous crime that you committed, that you generated money from. The crime that is in that thing that he is proving, when you don't have money, and all of a sudden you start having money, you start spending beyond any explanation of your income, that is called illicit enrichment. In some instances, it's called unexplained wealth. Those two crimes, coupled with conflict of interest, they are not criminalized under Liberian law. So I don't see where he's going with this, because the first step to criminal prosecution is that the law must be written already and say this conduct is a crime. It is established. Then you try to prove that this person committed this conduct. If it's the conduct, illicit enrichment, conflict of interest, unexplained wealth, if it's not written in Liberian law, nothing will come out of that prosecution. And that is my position.
Can I call into a point?
Go ahead, finish with my position.
I think the state has clearly gotten the indictment, and the indictment speaks of money laundering, theft of property, like as some of the rest of the other charges, as whether or not the defendant as accused have tried to unjustly enrich themselves. Now, to say there's no law on Liberian law, I think that is something that I would disagree with, because I feel like money laundering in itself, there are elements of money laundering, and those elements that include financial transactions that occur where there a financial transaction. That is not for you and myself sitting here to discuss, to prove. Oh my God. All right. And the second issue, whether or not there was an intent to conceal. I think the obligation is on the state. So we can't sit here and say the state doesn't have, cannot prove any criminal intent to conceal money. Neither can the state prove whether there were specific reason why these individuals took state money. The obligation is on the state. So for us to say that there is no law under law, I think we should be careful in reaching those conclusions. Just a comment.
All right. Hold on, Attorney Jensen.
Jensen, your life.
Yeah, Anthony Jensen, what did you go? I want you to clarify.
I think you want to pick up something.
What's the second? I don't want my laptop. That's my charge on. What you saying? What's the concern? Sorry.
Dennis.
No, my question is, hold on, Anthony. I got your point. So let me. So what Attorney Freeman is saying, the first thing they should prove is Finda stole. So,
but the indictment is not to prove. Listen, I think Jayweh laid that aspect out, right? The indictment is only for the grand jury to come out and say, well, and the state herself, the prosecutor went before the grand jury and said, these are the reasons. So to challenge the indictment, it means the grand jury themselves did not do well. Now, the case has been, the case is to advance for the grand jury. So whether the state will prove her case or not, we can say that there is no law on the books. Anthony knows very well that every lawyer will do that research and go to court and prove that case. So what I'm saying here, money laundering has elements, and those elements are found under Liberian law.
No, Attorney Jensen, before money laundering, all right, we lost him. Let me go to Attorney Freeman. You have something to say before Councillor Jayweh comes in.
I mean, Dennis, I pointed you to article in the indictment, point 86 to 90. So anybody who can read English can go there and read it and tell me how she stole this money, how much she stole, who she stole it from, where did she do with this money. You put that together and establish that there was a theft. The theft generated $1 million, $2 million, $10 million. This is where, when she got this theft money or this stolen money, this is where she put it. This is how she tried to invest it to make it appear like a legitimate enterprise. You got to start with what she stole, where she stole it from, how she stole it, who it belonged to, how much was stolen. You got to establish that before you go to say she laundered it. Yeah. So I'm saying, if that doesn't happen, what she did is still a crime, but it is called illicit enrichment or unexplained wealth. But if you look at the list there, the list of crimes from the beginning on page 1, there is no illicit enrichment there, and there is no unexplained wealth. So where are you going with it?
Councillor Jayweh, let me get your response.
So I wouldn't say that there is no case. I would say that the way the indictment is drawn, it is disjuncted. if you have a very good legal team, defense team on the other end, those lawyers will hold the state to systematically prove count by count what is it that the defendants are alleged to have done. Mind you, what we have in our hands is just the indictment. The pieces of evidence that led the state to draw up, I don't like the way the indictment is drawn because I think it just picked a bunch of laws and threw it all over the place. Instead of systematically dealing with what is theft of property, what constitutes misappropriation and trusted property, what constitutes money laundering, the linkages between theft of property and money laundering. Those things are not clearly laid out for me. So I think I said, if you have a very strong defense team, the state will have serious problem in trying to prove the crime or the allegation laid out in the indictment.
You sound like you agree with Anthony Freeman, except that you want to be careful.
No, I don't. He is saying that specific laws are not, for example, what he called it unjust enrichment is not a law in the layout in the Liberian criminal, substantive criminal law. It doesn't necessarily have to be laid out there. I'm saying that the state has the right to charge those defendants as the state has done. I just believe that the indictment is disjointed. A bunch of principle of law, criminal law, thrown all over the place without systematically going into count one. This is what she did that constitutes theft of property. Count two, this is what she did that transferred the money that she stole to acquiring real estate, engaging in real estate and so forth. So the thing about that is that the objective of an indictment is to give the defendant sufficient notice as to what they are charged with, and that though it is based upon such notice, that the defendant will be much more close with the authority to defend themselves. In spite of that, if you have a very good defense team, the indictment could be challenged on its face for lack of notice. There are other things that could happen that for which a motion to dismiss for the way the indictments were drawn. But if the defendant don't do that and decide to go to court, go to trial, they will hold the state feet to the fire to ensure that the charges laid out as they lay out will be proven and that the evidence are there. We don't have those pieces of evidence. I just think that they needed to do a better job than the one they did in order to throw the indictment out as it is. Because
let me ask you this to understand your point, right? So when you draw out an indictment, for instance, if you say theft of property, you should prove that in the indictment, or you wait until you go to court.
No, not proving an indictment. Like say theft of property. Take for example theft of property.
Right.
That, and I'm not saying this is what she did. That Finda Bundoo, in conjunction with others, stole $6 million United States dollars government money. Mm-hmm. And that there are documentation to show that on so date she deposited money in what you call it, Echo Bank. It went from Echo Bank to this other bank. So the idea that money was stolen, that one aspect of it. That could be count one. Clearly, count two could be that the money was stolen and used, and she used the money along with others to be able to acquire real estate, real properties. And that money from that real property was deposited into the same account or different accounts. So the money laundering aspect of it, you find the chain of connection in there. But if you say theft of property, you define it, you throw it, you leave it. You go to money laundering, you define it. You say what money laundering is, you leave it there. You went to misappropriation and trusted property, you define it, you left it there. You went into what you call it? Criminal association, you also left it there. The problem you created is that you have just read for yourself a bunch of laws and you flash all of them on the board without clearly connecting the defendant to what they did in order that the violation of these laws as listed, as stated. So in that situation, when you come to trial, which is not an indictment is not a trial, just a bunch of allegations charging the defendant. But when you come to trial, you are under obligation to count by count, connect the defendant to the crimes as you lay out, and the law that support the position for the crime for which you think the defendant should be prosecuted will also will have to correlate with the facts as stated. In the absence of that, a very good team of defense lawyers will go ahead and tear the indictment tear it apart to ensure that government, at the end of the day, the whole thing will be a bunch of confusion. Because if you can't establish that theft of property was committed, you can't establish what she did in stealing money. You can't establish how she took the money and bought land and started building homes. You cannot establish that the money from those homes that were rented out was put into some kind of account and then it would just, run from place to place. Then you have a revolving door for which the criminal procedure law requires that where doubt is created, it must favor the
for the point of information. I think the indictment has given sufficient reason for a trial to begin. The said Finda Bundoo established some fictitious company to which she transferred a lot of money, in which her daughter served as the principal manager for the company. So
I hear you, Dennis.
Jensen, how do you know that money that she transferring is not her own money? How do you know
that's
that?
the point, and that is not for us to decide. All that we are reading is that Finda Bundoo took government property, money, and she established a group of companies, and she put her daughter as head of that company, and they are alleging that she transferred state resources to that company.
What I'm saying, they gave us proof. They gave us proof of transferring the money. So Dennis, how she got the money? They didn't tell us.
Dennis, can I come in?
Prove right now. I think there will be trial. There will be witnesses. There will be documentation.
Okay, make clarification. Then
I'm not saying the indictment should not stand. I'm not saying the case should not go to trial, but we don't have the facts or the evidence that the state has that having charged Finda Bundoo and others with that they will have to prove. I'm just saying that the way it is organized is so disorganized that it will create a problem during trial. If you have a team of very good trial lawyers, they will be able to put the government whole team into confusion. That the objective for that is to create what the law refers to as reasonable doubt. And once a reasonable doubt has been created, the defendant or defendants are to benefit from those doubts. For example, if you cannot connect Finda Bundoo, when you cannot establish when she stole, let's say $6 million or more, then you have a problem right there. If you cannot connect it to how she bought the property because she was working, could she have gotten her own money or doing business?
This she violated the PPCC law.
Hold on. I want to, Atty. Freeman, you're saying the case shouldn't even is not a case. So are you saying it shouldn't go to trial? It will not go to trial because they don't have evidence in the indictment?
No, I'm not trying to predict. I'm just giving you my opinion about how I think the case will go. Mm-hmm. I'm not telling you that it must go this way or it must go that way. I'm telling you my professional opinion is that the crime committed is illicit enrichment or unexplained wealth. It must be on the face of that indictment, and it must be in Liberian law. Because when you go to court, that is what you're going to prove.
So
in my thinking, he did not establish theft because he didn't establish who she stole it from. He didn't establish it. Maybe he got his secret or evidence that they will produce in court, and they will prove it in court to show. But the one that I read, it doesn't establish that she stole money from government, or she stole money from foreign investor, or she committed armed robbery and she got money and then she converted that money so as to commit money laundering. I mentioned a thing. When we're talking, let's be specific. Indictment count 86, 87, 88, 90. Read it and tell me whether it established how much she stole, who she stole it from, when she stole it, what she did with it. It established nothing. So my professional judgment is that, yes, there is crime, but that crime is illicit enrichment, unexplained wealth. And we don't have it in Liberian law. He also charged her for conflict of interest. We also don't have that written in Liberian law. So where is he going with the charges? I know whether under civil law or under criminal law, the crime that you charge somebody with must be written in the penal code.
So let me.
If it's not written in the penal code, you are not likely to succeed at trial. That's my professional judgment.
So Dennis, Attorney Freeman is pointing simply to one area of the law that he says there's this theft of property. There's this money laundering. There's a provision for theft of property, money laundering, criminal association, misappropriation and trusted property. These are all the criminal law laid down in the Liberian book. The issue is that you don't prove a case in an indictment.
Right.
You raise those issues, those allegations that you think are necessary to be proved during trial. When you are before the trial jury, there's a jury and a judge, you are required to systematically, count by count, establish that the crime of theft of property was committed. Establish that the crime of money laundering was committed. If you don't establish it by the evidence, pieces of evidence connecting the defendants as charged, then the issue of reasonable doubt arises. But hey, the indictment may not. My issue with the indictment is that the indictment is not systematic.
So let me come back.
Obligation
In the indictment, let me come back. In the indictment, he laid out all the accounts that she took money from. He laid out all the amounts. So if he had all of that, why he left out how much she stole, who she stole it from, where she stole it, what she did with the stolen money, why he left all that out? And started with that she only was working for $4,000.
Yeah. Let me ask this question before you go. Are you saying that money laundering on its own, you can't convict anyone on it?
No. It's rare because you have to start with the proceeds of crime. So you can, let me tell you two ways you can commit money laundering.
No, can you answer this question?
No, let me establish the two ways to do money laundering. Let me just establish that. Somebody can sell drugs.
Can you agree whether or not?
No, let me establish money laundering. Somebody can sell drugs or commit armed robbery and got money. And they don't know what to do with the money. They can come to you and say, Dennis, say you got a barber shop. Can I give you my money and you put it in your barber shop account? And then from there, you transfer it to me. You didn't commit the armed robbery or the drug dealing. You only took the money from this drug dealer, put it in your account, then after 1 week, you transfer it. That means you're committing the money laundering, but not the predicate offense of drug dealing or armed robbery. In this case, it's different. The person who is committing the money laundering is the same person who they are accusing of committing the predicate crime, which is theft. So in this case, you must establish the theft. Then you combine it with the money laundering for you to make sense. If you don't, look, let me tell you something. I am not God to tell you how the case will go. I'm just a lawyer who has been involved in financial crime cases. And we had that experience at LACC. We did some investigation. We came out with a lot of people who had assets that their income could not explain. Did we charge them? No. Because we look in the penal code, there is no illicit wealth charges there. There is no unexplained wealth.
The test for,
So
test
if
for
you
property-
charge them and you go to court, at the end of the day, the issue will arise to establish the element of the offense. If you can't establish it, or you can't even establish the offense, they will throw your case out. So we didn't pursue it. So that's my professional judgment on the case.
You guys were lazy. Actually,
Jenny, let me.
Someone who doesn't
Jensen,
work.
Anthony Jensen, I want you to go. So Anthony Jensen, you are also saying that if the case go to court, right, and let's say for some reason they don't establish any proof of stealing, can they establish proof of illicit enrichment, money laundering, and the rest of it? Would that be something they can convict on?
Let me. I think my brother Freeman is he's not doing justice to what happened in the courtroom. The indictment, like Jayweh said, is not intended to prove who is right or wrong, or whether the defendant can be convicted. And the very good question you asked, Dennis, is that money laundering alone as a charge can be tried in a court of law, not just in Liberia, even in the great United States here. All right? There are elements, you and myself should be asking questions relative to the elements of money laundering to see whether the state or the prosecuting team can prove in a court of law this element that the judge will rely on to rule and find these individuals guilty for the crime being charged.
What would those elements be in this case?
One of the elements would be financial transaction. Was there a financial transaction? We are reading that Finda Bundoo bypassed the PPCC law and she established a company to which all of the money the guys are talking about were indeed were concealed in the company that she established. Can the prosecuting team prove concealment, that Finda Bundoo did conceal state resources into this company that she established and named her daughter?
You talk about state resources, right? So to talk about state resources, you must first establish that she took state resources, right?
Of course, that's true. That's true, and I believe the prosecuting team do.
Right. So now, what will be the evidence that is needed to establish that?
Okay, there are a series of evidence. How do you get money from the Ministry of Finance in Liberia as a government official? There is the national budget is sitting right in there. The president's office has his portion. The president's office has a portion of the national budget. They do financial transactions as to how they get the money from the Ministry of Finance, or from the Ministry of Finance to approve, and then they go to the central bank and get the money out of there. So that's what I started saying from the onset. Finda Bundoo alone probably just a bit in this case. When the case goes to trial, maybe we might hear many other individuals being named or being attached to the trial. So for us to sit here and say we want clear evidence, I cannot see the voucher that was prepared. The voucher that came, just the point we come in. The voucher that came from the Ministry of State, for which Finda Bundoo withdrew the money or went to the Ministry of Finance for them to sign that voucher. And then forward that prepare, I don't know how you call that, after voucher is prepared, when the voucher is approved, after you go through all of the stages, there's a whole round. I have been at the Ministry of Finance, I have followed through voucher in the system before, and I know how tedious it is. So Finda Bundoo alone cannot just get and take those millions of dollars from the state coffer. So for us to sit now and say, well, there's no case.
So hold on. What is the evidence of taking that money, or what would evidence be that she took money from the state coffers?
Okay, that's what I'm saying. So the voucher is prepared. Before coming in Jayweh, before the voucher is prepared for the Ministry of State, maybe Finda Bundoo name or her company name is on some of those vouchers. And when the voucher, when there's evidence that this company was enacted or there's an article incorporation from the Ministry of Foreign Affairs that the company is legitimate, and there is voucher in the system in this company. I'm just assuming. I cannot prove because I'm not in the case to go and ask for those vouchers to see which of the vouchers the state is relying on. So when the vouchers are found, and to the point where check is prepared from the Ministry of Finance, and that check went to the central bank, and the money was withdrawn in the name of the company. I believe these are pieces of information that the state probably, I'm sure they have these pieces of information. If they don't have it, they wouldn't have been, maybe they wouldn't have convened the grand jury. But I'm sure they have these pieces of information. They convince the grand jury, these are the checks we have, these are the vouchers, these are some of the financial transactions. And then maybe from there, money start going outside Liberia, from here to whatever international partners she have. So if the state have all of these pieces of information, it's not to get them to the grand jury, just to convince the grand jury. At trial, it is expected at trial, these pieces of information will be presented, individuals will be called to testify, and then at that point, we'll get to know the truth of this entire matter. But to sit here and say money laundering is not a charge, cannot be tried, I think we will be
I think
behind with.
Councillor Jayweh, let me come to you here. Councillor Jayweh, so the whole thing here is Finda Bundoo, the first thing she did, she stole money. Then secondly, she used the money.
She allegedly.
Right, to invest it. So in that case, so the main thing here is stealing the money. So if it cannot be established that she stole money, does everything else fall flat on its face?
So let me make 1 or 2 clarifications first. First, under the Liberian law, money laundering is a crime.
Right.
A defendant can be charged for money laundering. Attorney Freeman confused the public when he said that you must establish, or there need to be established, that a crime has been committed and that the fruit of such crime is used for money laundering purposes. Only when that is done before you can establish money laundering. That's not true. A theft of property is a provision of the Liberian law that requires that if you took something, simply put, if you took government money and converted it to your own use, like in the case of Finda Bundoo and others, they should take government money and they should then convert such money to the use and benefit of a company or companies, along with the defendants that are in there. So you don't have to prove theft of property at the end of the day before you can charge money laundering. Depending upon what the facts are, you can charge theft of property, you can charge money laundering, you can charge misappropriation of trusted property. The issue surrounding that is that you have to clearly be able to lay out the allegation, which are not the facts at the time in the indictment, that you wish to prove against the defendant. Now, when you get to court, when the state gets to court, the lawyers will be required to establish count by count those allegations that they have raised. They don't have to first get a judgment for theft of property before they can go for money laundering. They can lay out as they lay out, depending upon what facts and what evidence they have. Mind you, the state have had, I think, over 1.5 years to start to investigate some of these properties, how they obtained it. You don't necessarily need to have in the law illicit acquisition of property. Theft of property alone, that's sufficient. Yeah, you don't really need to use the word. There need to be the law.
Councillor Jayweh, that's what happened at the case with the Election Commission. They did not have insider trading in the penal code, so they couldn't. So that's how that case.
So you will see the state did not. You will see in the indictment the state did not.
It was the same. What the guy named Cllr Martin.
So it
was the same Cllr Martin that went and charged the woman with insider trading, knowing very well, or maybe you are ignorant, that there is no insider trading in Liberian law. So he put insider trading and he went to court and they said, show me where insider trading is in Liberian law. He couldn't show it. They threw the case out.
But
let me correct the information on money laundering. I was very clear. There are 2 ways to indict somebody for money laundering. One, you are not a participant in the previous crime. Somebody did drug dealing, they did armed robbery, they got money, they give it to you. And you try to hire that money into investments. You can commit money laundering. But in the case of Finda, they're not what they're saying that somebody gave her corrupt money. They are saying she stole money and then she took this stolen money and she tried to invest it. So they are accusing her of both the predicate offense, stealing, and the money laundering. So it's different. So I have never said that money laundering can only be
or commission. You can only charge it if the person is involved in a predicate offense. I made it very clear. Different person can commit crime and give you money, you can launder it. That's one way. You yourself can go and commit crime and get money and launder it. That's another way. In the case of Finda, they are accusing her of committing a previous crime in addition to the money laundering. So it's not in Liberian law. Just because she was poor and she spent money, it's not in Liberian law or illicit enrichment. If you don't charge it, you're going to court, you will lose.
I don't think that is possible. Finda Bundoo could be the same person who stole government money. Finda Bundoo could be the same person who invested the money. Finda Bundoo could be the same person who turned the money around to make it legitimate. Right. All of what the indictment is saying could be possible, provided the proof.
Before you go on, right? So if they cannot, because for her to launder the money, it means that two things should happen. Or let's say, tell me if that's not true. That either somebody got it illegally and gave it to her, or she herself got it illegally. If those two things cannot be.
So she herself, by the indictment, who have committed theft of property by stealing government money. Right. The money she stole from the government, allegedly, she could have invested into real estate. The money from the real estate, she could have brought it back into other businesses that she had. So my question
is, if it is not established that she stole it, then you can charge.
So if you cannot,
the charges have been made.
Dennis, let me answer your question. So if you cannot, so if the state cannot establish theft of property, then the state has problem. The state will have clear problem establishing money laundering. Because, for example, let's say Finda has 6 million from somewhere. She was not selling Kobo somewhere. She was selling. She had a lot of money, and she invested her 6 million into real estate. The government would, if the government does not establish that she stole the 6 million or how much million you're talking about, then money laundering cannot become an issue any longer, because the money she allegedly stole, and it is alleged that she invested and into several companies, it doesn't exist. But when it doesn't mean you have to prove theft of property before. You can allege theft of property. You can allege misuse of misappropriation of public fund. You can allege money laundering. All of these charges, you can allege them, but the burden of proof rests upon you. I wouldn't say that Attorney Freeman to say that because she was poor, because she was not doing anything. And
in the indictment.
Yeah, but because the indictment says that, so that it would become difficult to prove during the trial. You have to have the pieces of evidence that the state has in its hand. None of us has those. I guess they may have the bank account. I guess they may have the voucher. I guess they may have the transaction between central bank and her business. I guess they will have money going in, money coming out. All of these things that constitute money laundering may be present. I am just concerned that the way the indictment is drawn, it is so loosely drawn to the point that whether she was poor, whether she was not poor, that doesn't really matter to me. What matters is that did she steal the money?
So the way I'm understanding it now, I'm understanding it that you are saying the same thing Attorney Freeman is saying, but Attorney Freeman is saying it in a harsh tone.
No.
I think. Can I
explain? Let me explain, right? So what we agree on here is if this case goes to trial and the government cannot prove that she stole money, then money laundering issue is irrelevant. Is that
money laundering issue is irrelevant?
Can I interject?
Irrelevant. What you call it?
Hold on.
Money laundering is irrelevant then. Misappropriation and trust property is irrelevant then. Acquisition, whatever.
Conspiracy, facilitation, all of them going out at the same time.
All of those charges will be going out. But what we need to be very careful with is that because you and myself, or because we who sitting on this panel do not have the pieces of evidence that the state has to lay the chain of connection, we cannot say there is no case. The only way you can say that is that you are a lawyer in the case, and discovery process are taking place. You have everything the state has the attorney over to you. In the absence of that, you're speaking prematurely.
Right.
I agree with you. And this is why I want to add.
Go ahead, Anthony Jensen. Anthony Jensen, also let us establish that if theft of property cannot be established, everything else out of window. True or false?
No, I don't agree. No.
All right.
Every charge has elements to be proven. Every charge has elements to be proven. Theft of property, there are elements for theft of property. Money laundering, there are elements of money laundering. And all the other charges alone, the judge will be looking up to these lawyers, the prosecuting team, to prove this element one by one as per charge. These charges can hold or can be dismissed if this lawyer, the prosecuting team cannot prove this element. Let's assume there are 3 elements to money laundering, and you as a lawyer, you're in a case. Your research should be, how can I prove this element to prove to the jury or prove to the judge, yes, that this charge will lie. If you're a lawyer, you cannot prove. If you can prove even one, the judge can grant that charge, and that charge will go against the defendant. You go to charge number 2, theft of property. When the elements are listed in there, and you prove those elements, the charge will work against the defendant. But then assume all of these charges.
If you can prove that theft of property, can you prove money laundering in this specific case? I'm not talking general.
Yes,
okay.
yes.
Tell me how.
I can tell right now there are elements. That's what I'm saying. Maybe you don't understand it because you're not a lawyer. But the element of money laundering are there. If you take money laundering and you define that, you ask for the element of money laundering, you will see them. There may be similarity between. There may be similarity of money laundering. The element, there might be some similarity between these 2 charges, but it doesn't mean that if you don't prove theft of property, you cannot prove money laundering. Money laundering, there are elements of money laundering. So which when you prove them, money laundering holds. If you cannot prove theft of property, money laundering holds. If you prove theft of property, you cannot prove money laundering, theft of property holds, money laundering doesn't hold. So every charge has its own element to be proven in the code of law. And I think these lawyers should know all of that. Yes.
So I think Jensen is very correct. All the charges that lay out in the criminal law have to be proven when you charge them.
Right.
But the facts that you use to be able to lay out those laws is the chain of connection of the crime. When the chain is broken, the rest of the crime will go away.
No, Jayweh,
So the government, the entire case of the government of Liberia is that Ms. Finda Bundoo stole government money, used the government money to open companies,
right,
build buildings, homes, and lease them out to people,
right,
and is making profit from it. Simply put, that's what the government is saying.
Yeah.
If the government cannot, in the first instant, prove that Finda stole, let's say, $7 million to invest into her business, everything else falls apart. The rest of the elements are immaterial. The rest of the evidence, the rest of the elements you're talking about, they are immaterial because you started off by saying Finda Bundoo stole $7 million allegedly, and she put it into several businesses, and it is the businesses that are now turning that money over to be able to enrich her. If you cannot establish that theft, then you got a problem. If you want to charge money laundering alone, you can go ahead and charge it. But then you will be required.
I think we are just doing some supposition here.
So the other issue with that is that it could be like in the case of people who engage in drug dealing. Somebody is a drug dealer, received $200 million drugs in Liberia, and then he gets all the drugs sold, or his client or whoever he's dealing with pays him off, and he gets the money, and go to Echo Bank and say, Echo Bank, I want to put my money here, the $200 million. In the next 2 weeks or so, you will help me to be able to start the real estate business. So mind you, there was a crime for money, for what you call it, drug distribution, drug sale and whatnot, that led to the $1 million. That's another way for money laundering for it to stand on its own. But if money laundering grows out of the idea of theft of property, The chain that connect money laundering to theft of property cannot be broken. Has to remain intact, meaning the evidence you have to prove money laundering onto misuse of public fund, every other thing comes from the theft.
I think
the element Attorney Jensen is talking about, those elements will come into play. I am just only querying the way the indictment is drawn because it doesn't give sufficient notice to the defendants as charged. But be as it may, the state may have linkages, pieces of evidence, growing from how much money was taken, growing from when Finda Bundoo established the companies. They have an article in corporation. They have the businesses that she had. They have, I think one of them is called Gracia Ride. One is called Gracia Ride to to all of the other real estate company. The idea that she was poor, maybe the state was trying to insinuate that this woman is a poor woman. How can she come from selling cobalt to get all this money? But that is not necessary at all. I would not have said that. I would just basically.
So let me ask this question. I know we kind of beating this one to death, but I think it's getting clearer now to me. But I mean, 40 persons. Let's say we're talking about Finda Bundoo. What's for the other people now? I mean, it's not too clear what it did, but what would be the challenges proving this against 42 persons?
The charges are that's the cleverness of the lawyers. And I started from the onset that lawyers normally throw out these charges, especially with the multiple questions involved. It is very likely that somebody among the 40 persons could be found guilty for theft of property alone and not money laundering. Correct. It's possible that someone in the group could be found guilty for another charge and not money laundering or not theft of property. So all of these individuals, they are in there, and so the state herself, she has to be clear because she has the burden to prove. What are these 40 persons? They put the names in the indictment.
The state has the burden to prove.
Right.
Yes,
it's also possible. This is what again I wanted to say. It's also possible the 40 person could be set free. This is an allegation so far.
Right. So let me ask you. So if Finda Bundoo, because everything, the source of all this thing is Finda Bundoo stole money. Mm-hmm. So if you can establish that Finda Bundoo stole money, then the rest of the people they will just walk out too.
Yes, because let me come in.
We have to be careful not to reach a conclusion.
Let me come in quick, right?
All right, go ahead, Freeman.
Finda Bundoo, all these people are put there most likely because either they receive check from Finda or they took money to the account. So they are tied by way of conspiracy or by way of facilitation. So then you're speaking like a lawyer so much. Because he tied the entire case around Finda. And he tied it around the entire case around. He tied the right case. Yes. He tied the case around Finda, and more specifically, it is tied around that theft of property. So, because like I said, if he has said John Brown did corruption, let's say George Weah did corruption, and George Weah gave the money to Finda, then Finda, the one who did the laundering, and George Weah did the corruption. Let's say fraud on the internal revenue or bribery. That's not what he's saying. He is saying theft of property, Finda stole money, there was conflict of interest. He's not saying George Weah did it and give it to Finda. If he did it there, we wouldn't be looking at money laundering for Finda. And the other people will be the facilitation and all of that. But he is saying she stole. So for her to launder, if she is the same person who's doing the stealing, you must add those two together. You can't leave them apart. They can't survive separately. They must be tied together.
I think we are making some mistakes here, and I don't want us to leave from here with that mindset or leave that mindset with the public. Money laundering is just one of those charges. Theft of property can stand by itself. Mm-hmm. Now, all of this discussion we're talking about here, the money we're talking about, the source of the money from the national budget. I started laying down that foundation earlier. Finda Bundoo is now working. She wasn't working as an individual. She was in the office of the president. The only way, even talk about millions coming out, came as a result of looking in the president's budget.
And where are you getting that from?
Getting what?
What you are saying now, where are you getting it from?
It's a common sense in government. No. What I'm telling you, the indictment, we haven't read the full indictment, and we don't have all of the pieces of evidence. Even the thing I'm telling you, the cycle of financial transaction in government may not necessarily be in the indictment, but it's a commonplace. Jayweh didn't give Finda Bundoo money from his personal account, or the office of the president didn't run without the national budget. So the transaction over there, that's what I said. We can, in fact, I don't like the way we discuss this thing, because I expected us to even look at the finance ministry, how vouchers are prepared and sent to the finance ministry. So if they say Finda Bundoo did not,
that's a trial part of it.
I agree. But
if you go to the finance ministry, you just on a fishing expedition.
No. Our purpose of discussion, that's what I'm saying. We leave the main issue we should be discussing, because our purpose is to enlighten the public as to what is happening.
Dennis, what Attorney Jensen is referring to could be something that could come out during trial.
Right.
If the government believes that, the current government believes that the Minister of Finance or the budgetary, the director of budget or whatsoever he is, or any of those officials need to come to
the Controller General. Why will you release money to this company when you should have known this Finda Bundoo company was just some fictitious company that was established? So the Controller General, there's a segment over there. All the
director of budget, the Controller General, all these people might come to court.
So there's a whole. This is a ring that this guy can be. Yeah.
But what we're saying is that.
But could that be kind of implied in the indictment?
No, they don't necessarily need to put in an indictment. If they wish to use the Minister of Finance expertise from the Minister of Finance to come and explain what is the transaction process.
They will either agree to be state witnesses, or they will just be found guilty. They themselves can be drawn in the case.
They can subpoena them. To come and testify. Now, during the testimony, which is trial, if it links Samuel Toya, if it links Samara Warikoli and the rest of them who were there, including if you can draw the net to cover all of them, then the state could file a motion to add them as co-defendants.
That's what I'm saying. So in the indictment, if they were to kind of hint on how Finda Bundoo stole this money, then we could see all the linkages, right?
Correct, but
there's a hint.
Dennis, maybe the state, in drawing the indictment, they thought to be as vague as possible, which I think is a terrible thing to do.
Right. Because when you
because you are as vague as you are, then during trial you had the difficulty in trying to connect everything else that you wish to connect. But as it is, the state may have evidence that we don't have, that they could be able to establish that Finda Bundoo allegedly stole this money, and then during trial the burden will be on the.
That would be a sucker punch.
Yeah, but during trial, the Finda Bundoo and other will say that they didn't steal the money. She may bring President Weah to court to testify.
She wouldn't do that.
I would subpoena if I'm defense counsel. I would subpoena.
Jayweh could be subpoena. Like I'm saying, any other voucher that will prove the come from our office.
I would subpoena them. Or you can subpoena the Minister of State. The people who are there, they will have documentation to see.
Yeah.
So I talk about it for the two. And Anthony Freeman will come to you to say, well, this is just an indictment. They don't have to put everything there. They can still go to court and produce those vouchers, produce things that link everybody and connect.
But then at any point, they asked that it needed to be in the indictment.
No. What I'm saying is,
at any point, they asked it needed to be in the indictment.
No, that's not what Dennis said.
That shouldn't be the point of the argument.
I didn't say that. My judgment is that I don't see the explanation for theft. Even if that one line, I don't see it. So I don't see. Mama, give me a chance. You have your time to stay. Give me a chance. I have worked with LACC. I have worked with FIA. Both of the agencies combined, I spent 8 years working in that industry.
You want to their profile?
I am talking I have spent 8 years in the industry. Before that, I worked as a financial analyst and a controller. Okay. So I am not speaking just because I want to speak.
No, I'm not saying you are ignorant.
I am saying, yeah, give me a chance, bro. I am saying, you know why I came on the discussion? No. I want to raise the fact that those are laws that are needed in Liberia if we need to fight corruption. Because from experience in LACC, we encounter a lot of those instances when somebody was making 500 and we saw them with millions of dollars in property. Okay? So it's a problem in Liberia. Conflict of interest. People at the Capitol building, they pass budget, then they go to set a company. And then the budget that they pass, their company B, they want to deliver it. At the end of the day, most of the projects are not finished. But that's how they get the riches in Liberia. And then they use it for election, they win, they go back, they roll the same thing over. So I'm in this discussion because I want to highlight that we need a law on conflict of interest. We need a law on illicit enrichment. We need a law on illicit wealth. I'm not here to support Finda. In fact, if you ask me, I will tell you all the corrupt people, whether they are in CDC, PPP, UP, they need to be charged and prosecuted. But I will also tell you, if you draw out an indictment and you charge money laundering, and the person that you charge money laundering is the same person who you accuse of the predicate offense, you have to prove all two. So if you go to court and you're not able to establish the predicate offense, you will not be able to establish the money laundering. That's my professional assessment of it.
Lawyer is to prove their point in court. Nobody's saying that.
Yeah, but then why are we here? Why are we here? We are here to give our analysis, our professional opinion. I'm not telling you that that's why the judge will rule per se. I said, in my judgment, they don't have a strong case. And that's my point.
Okay.
Thank you. Ladies and gentlemen, if you are just joining us, this is FOL Justice Forum. We are discussing the indictment of Finda Bundoo, Thelma Sawyer, and 40 others charged with money laundering, theft of property, and all the 9 yards. If you want to be part of the discussion, please call our number that is scrolling in the text there. That's 605-313-6004. The code is 791-403#. And let's hear you. But, anytime there is case, first of all, I didn't hear your Councillor Jayweh on the 40 person, all the group of people. If Finda gone, then all of them gone.
So the 40 or so people could all be facilitators or could be convicted separately for money laundering. Right. Could be convicted separately for theft of property, depending upon what role they play.
Right.
Now, the way the chain is drawn, it is drawn around the center point of the point of concentration of the entire case is around Finda Bundoo. Maybe next will be her daughter. Everybody else could be facilitators. If they're not convicted of money laundering, they could be convicted of criminal facilitation. And so if they cannot establish the central point if the state cannot establish the crux of the entire case, everybody else could likely be convicted or go free, depending upon, could be separately convicted or could be convicted as Finda Bundoo could be convicted. And then they all could be sentenced as per the law, or they all could be set free. Mind you, in Liberia, when the state loses a criminal trial in a trial court, which is the Saki court, in this case it would be criminal court C, the state cannot appeal. So then that's the end of the case at that point. If the state loses the case as it is before criminal court C, the state cannot file an appeal, announce appeal, or proceed to the Supreme Court. And that's the end. On the other side,
Jensen, what do you think?
On the other side, Finda, others are convicted.
Say that again, I didn't get you.
So I say, on the other hand, if Finda Bundoo and the 40 people listed in the indictment are all convicted, they have the right to appeal to the Supreme Court for review. But the state doesn't have that right if it loses.
Attorney Jensen, what do you think will make this case stronger for the government?
You're breaking it. You're breaking. I didn't get you.
Can you get me now?
Yeah, I tell you.
You can hear me now?
Yeah.
What do you think can make this case? What do you think can make this case stronger for the government, for the prosecution?
For me, I think the prosecuting team, so far, the information we are reading, they have a case. The only thing that
I'm using strong.
That's what I'm saying. I think they get a strong case because I think they have a strong case. Just by the summary of things I'm reading. All right. Finda Bundoo has been, of public record, she's been one of the famous person all around. And to hear that she bypassed the PPCC, I'm not sure such a statement would have been made without evidence. Now, we do not have the evidence.
I don't want to go there to say, well, the lawyers are good, so I don't think they will do something wrong. I'm saying based on what we have.
Listen, we have the grand jurors. All of these people in agreement came out with a true bill.
So your line is these guys are not stupid, so they will not make mistakes. I don't want you to think.
Listen.
So Dennis, I think your question is soliciting a fact that does not exist. What do I mean? What I mean is that none of us here has what the state
record,
has. So to say what can help to make the case stronger is to assume that the case is weak. The case, in my mind, is not weak until we have the evidence that we have. The case, in my mind, is not considered strong until the state can prove weak until the state cannot prove the allegation laid out in the indictment. So that is a trial question. But because trial has not started, and because discovery has not started, evidence that the state has is not exchanged with the defendant, it will be difficult to say whether the case is weak. My contention is that the indictment is disjointed. Doesn't mean the indictment is weak. I just believe that the way it is drawn, it is problematic. It becomes difficult to prove during trial. But again, they may have different strategy than what I'm thinking of, and therefore I couldn't say the case is weak, and therefore something needs to help to make it stronger.
Councillor Attorney Jensen said the case is strong. You agree?
Well, I wouldn't say the case is strong or weak because I don't have the evidence. Attorney Jensen may be saying, from what we have seen, I would say that the government has laid out a case that it will be required to prove in trial. Whether it's strong, it will come from the evidence. I think when they lay out a case, and a lawyer with a professional opinion should be able to tell that they have a strong case. Attorney Freeman, what do you think?
But Dennis, so far I am the only person here who is telling you my professional judgment is that. But then you give a superb example. Then you say you're the right one there. Then whether you're the same person who produced the story about neck.
Yeah.
So what's in the neck? What's in the neck?
Why will you say you don't know professional?
Give me chance, brother.
Your opening statement will say you the only professional person here who give you professional judgment.
Who say that the case is weak?
I say the case is weak. That's my position from beginning to now.
What do you have to say?
So you guys got different position, and that's why it's important for people of diverse views to give opinion.
Counsel, as a lawyer, what do you have to tell
I say the case one is weak. Yeah. I say that two, the crime that he is alleging in that indictment, it points to unexplained wealth, it points to illicit enrichment. It points to, he said, conflict of interest. Those are things that are not written in Liberia penal law. So he will have a problem when he go to court. That is my professional judgment. Dennis gave a perfect example of neck. The same Martin, or what you need, Clark Martin, he left his expensive language. He went and charged Deviator Brown were insider trading. He had no idea what they call insider trading, what constitutes insider trading, whether in Liberian law, but a law fancy. So he gave me chance. Give me chance. He went and charged the woman with insider trading. It could have been that she committed the offense, but he put the wrong charge. He went to court. It was dismissed. So I'm saying the identical Cllr that did that.
But the facts are not the same.
He came back again. He put another fancy charge together, and he's trying to proceed on it. I'm saying it's weak. Go back and establish a proper case. Look, let me tell you, I want corrupt people to go to jail in Liberia. But build a strong case. Don't put mumbo jumbo on the paper and send it to court because it will be dismissed.
Counsel, you are honoring your legal obligation, your professional responsibility ethics require you not to come stand up publicly and say, well, God is not here to defend himself. So leave his personality out as to why he did in the case about. Today we are talking about the issue of money laundering, Finda Bundoo, Anita, her daughter Anita, and other guys who have been allegedly accused. So why don't we just stick to this issue? You have all right.
Because the example is synonymous with what we're discussing. I am alleging it's synonymous. I'm alleging that the crime he is charging is not in Liberian law. And I'm alleging that he has a habit of charging crime that is not in Liberian law. So if he doesn't have illicit enrichment or unexplained wealth in Liberian law, and you go and you establish conduct that points to illicit enrichment, right? It's going to be dismissed because it's not in the law.
Let me bring in our callers. Let me bring in some callers here to weigh in. Elvis Morris, you are first. Go ahead.
All right, thank you, Mr. John, and hello to the panelists. On the issue of money laundering, I think you guys are maybe complicating it a bit too much. We're not lawyers, we're lay people. But I think Councilor Jayweh was on the right track when he was talking about a chain. Because you have to prove the source of the money was illicit, meaning it was illegal. And you have to trace it up to the point where that person has legitimized it through maybe a business. And they're washing the money, meaning that they're taking it from a dirty, illegal money and making it into clean, legitimate money through that, that enterprise. So you have to prove that. So if these guys can go back, which is almost like going back in time, that's why it's important. That's why in the United States it's easy to prove money laundering, because the FBI agents are there through multiple governments. They're not people who are just coming into a government and then trying to go back in time. It can be done, but it's harder to do it that way because you wasn't in the system. You didn't see it from this, from its beginning and trace it all the way to its endpoint. So it's going to be difficult to prove that all of the money now that she has, other businesses was gotten from the initial illegal or illicit means that she stole it from the government or she went there and transferred. The money that I saw, that $399 million Liberian dollars, like 2.3 million or 2.4 million at the time when she got that money. So what is her justification for that money? It can be that she, it's improbable, but it could be that she got a bonus. It could be that she got a signing bonus, like Amar Corner and those guys who was doing something at the car, getting $300,000 in a lump sum for signing bonus. All type of funny thing goes on in the government with people getting, bonuses and other, money that is quote unquote legal. The Liberian taxpayer and the Liberian citizen may not like it, but those funny things happen in government. So my point here is that this case has to be proven from its, from the start all the way to the end point that this was illegal money. Now she's using it to try to legitimize it through, legitimate businesses. That could be difficult to prove. Yeah. And he's right. Councilor Freeman is right. Martin, they try to charge the Brown with insider trading. We don't have a stock market in Liberia that you can go and buy stocks, get insider information, and then use that information to your advantage and at the disadvantage of others and trade stocks.
Who said that only we are insider trading?
Very good.
It was a conflict of interest. She had a brother and she put him in a position of...
Even conflict of interest is not in Liberian law as a crime.
Thank you for taking my...
Thank you. Let me bring in one more caller here. That's Joe Male Mature. Mr. Mature, you're live.
Yeah, thank you very much, Mr. Jai, for taking my call. Let me recognize my former professor, Professor, Jayweh, from the, we're for Cllr criminal justice in Liberia. I want to make a couple of points, and then, you guys, it's left for you guys, here is the thing, first and foremost, what prompted this trial? I could reveal that it could be politically motivated, something that, I independently, stand by, politically independent. The second one is that if he will come to an equity or come with clean hand, let's look at, let's retrospect on President Walker's recent statement that if you, get your illicit money or get your corrupt money, you should invest in Liberia. So what is prompting the government now to go after past government officials? Those are the kind of things that, got me so confused. And then again, the government, this government, the Joseph Walker administration, prior to, taking office, they took some money for NASCAR. Have you investigated that? So look, there's a lot of things, so it raises eyebrows when you try to come after people, prematurely like that. It reveals, political motivation, So I dismiss this trial, if I were in a position, trust me, Mr. Jai.
But you dismiss it politically, right?
Yeah, he's not a judge.
Right. So come on, our Friday night show. This one here we want to talk the legal side, so we don't want these guys to do politics.
You see, there's no basis for this. Absolutely not. You see, because the government is weak on corruption. So I agree with you that you're trying to explain the legal side of it. I do appreciate that. Yeah. But I'm saying that this is a waste of resources, for taxpayers, So I just want to say.
So you did criminal justice. What did the law say?
Well,
Yes.
I heard, a lot of things, so when it comes to money laundering, I know the elements, but these are at times difficult, more for countries like Liberia, with post-sophistication, to prove these kind of cases, it's kind of a little bit difficult. Take for instance, when you go to West Union, Mr. Chair, they ask you the question, is there money, this transaction, is the money laundering, the care party, all the other things, they got people that track you.
Thank you, Joe.
The bank in America, you tell huge amount of money to the bank. Start tracking where you get the money from, So the country is full, sophisticated. The country doesn't have the sophistication, to go after these kind of cases, apart from being politically motivated. Thank you, Mr. Jai. You have a great week, man.
Thank you, man. Thanks for calling. Let me take a call from 508 area code. Your name and where you calling from? Call your name 508-782-3222. Your name and where you calling from, sir? All right, when a person ready, they will talk. But so
let me provide some information for my brother, my dear counsel, Freeman. I kept hearing Freeman that there is no law on the Liberian law as far as conflict of interest is concerned. Am I correct?
Hello?
Okay.
Hello?
Yeah,
so
criminal law.
Yeah, are you hearing me now?
Yeah, okay, go ahead. Your name and where you calling from?
Yeah, I just thank you. The show is very educative, and my name is Sarah Snell from Massachusetts.
Hi, Sarah.
Thank you, Brother Dennis. I think very well-meaning Liberians who make well for our country should be void of politics. My comment is in reference to the guy who just left the line, And I think we should go for people regardless of political party institutions who form money
who live questionable life. But back to the topic on the discussion, I think I want to agree with the two panelists and disagree with Freeman on the issue of the indictment. And I think the state do have, if the state have evidence, where those evidence are necessary is in the court of competence jurisdiction. So the state is going to reveal the evidence when the case has resumed, by the court. So I agree, every one of us, we, speculating, but I think to be able to come up with a definite statement, it means that you have all of the evidence that are necessary before coming up with that statement. And I think we should not, we should try to avoid that, and let's wait for the process to take place. So I guess as legal and experienced those panelists are, those who are also bringing out these indictments are people who are also experienced in law and institutions, And so my thing is, let us wait and see what the evidence, with respect to the case is. I personally do know Finda Bundoo because I interacted with her when I was working in Maryland County. And she was like in Rewaji, operating a restaurant.
But Sarah, we want this movie
about $6 million. That is not that money, I guess, cannot be getting in Liberia from a little cover shop.
But you got to prove it, Sarah. Sarah.
Put all of that together, there must have been something.
Thank you.
That she might have done. But right now, we don't have all of the evidences before us, and so we wait for the trial to resume.
Thank you.
At which point in time, we hope that the government lawyers will be able to bring what evidence they have to be able to prove their case.
Thank you.
But I think
thank you.
Public official to be in the process of serving the interest of the public and not putting money
to
the personal, well-being into the family. That is totally unacceptable.
Thank you. Darling Warwood, you are live.
Thank you for having me, Danny. So, better you keep saying that we should forget the politics and discuss the law. You can't depose this case from politics because it's politically motivated. You can see politics all over this case.
Okay.
So the issue of Finda, my question is, why Finda? There are other big fish in this river. We got Jayweh, who squandered his wealth, was living out. He had absolutely nothing. The property he had in Nashville was run down. And we have Bill Jayweh, who was the former court director. I didn't even know there was anybody in Liberia called Bill Jayweh on the TVC into power. Nathan McGill, he was renting prior to coming to power. He had absolutely nothing. Samuel Jayweh. And the list go on. Why are they going after Finda Bundoo? They are going after Finda Bundoo because she's a soft target, because she doesn't have the name recognition, and she doesn't have the backing. So I would say, Joseph Barker, I have always said that he is not a serious person. He is not serious today. He never been serious yesterday. He's not going to be serious tomorrow. This case is going to end on the Samuel Jayweh case. It will tend to a tattoo at the end of the day. It's not going anywhere. Mark my word, this is not going anywhere. We are talking Liberia here. I know Liberia. I have been Liberia, and I know exactly what they're doing after when it comes to law. They are just using Finda Bundoo. They are scapegoating her because they basically have nothing to do. So it's like, let's just do something so we can keep the people busy. This is a distraction.
Thank you.
Complete distraction. Thank you.
Thank you. Okay, maybe our last caller, Emmanuel Tukba. Emmanuel, you are live. Go ahead, sir.
Yes, hi. Thank you, Dennis. I have a question for Anthony Jensen. I think I joined at a time where I heard you talking about the violation of the PPCC Act or PPCC law. You say it's criminal. Can you clarify that? Because, under the current leadership, we see a lot of violations of the same PPCC Act. Whether a violation of PPCC Act is criminal. And then,
I think you're talking about the public works minister. He said he was sorry. Go ahead.
Yeah, he was sorry and they forgave him at the Senate. So I don't know why can you violate law and then they forgive you in the Senate and no prosecution. But in terms of the whole criminal prosecution in Liberia, I mean, I'm not a lawyer, and I got, like I said when I called before, I got a lot of friends who are lawyers. Criminal? Who are the criminal? Does Liberia already have criminal lawyers? Because look at Finda Bundoo lawyer. It will be the same people who, when somebody slaps somebody, they will go represent that person, and then when the indictment for criminal cases or business law, whatsoever, the same people representing the same people. What is this? Can you show a demarcation or clear distinction between what is going on in your legal profession for all the laymen to understand what's going on?
Thank you. These are all the colors we have. I think Jensen, they call your name, so I'll begin with you.
Yeah. So that's why I'm curious. Okay, let me start by saying this. Why it is true that most Liberians pretend to be lawyers. There should be no time that I will sit on a show to see someone discrediting Liberian lawyers. Because these individuals, they spend money, they took a long time to go to law school. They may not know all of the provisions of the law, but they are lawyers, they've been qualified to practice law. Having said those, the issue of Finda Bundoo, the crux of the matter is that she violated the PPCC law, to which from a company created, a group of companies she established, she used state resources and siphoned or concealed the money through that company. So that's the link that I would bring into this. Like we all have said here, we do not have the full evidence as to those pieces of evidence that the prosecuting team are relying on. So we can say, all right, Finda Bundoo is guilty or she's not guilty. But from all of the circumstances we are hearing here, or we have heard or we have read about, we are only saying that Finda Bundoo has been accused of stealing state resources and concealing those resources into a group of companies that is now run by her daughter. Now, before that end...
The follow-up question was about the PPCC, right? You say you are saying everything that PPCC, but PPCC law has been violated over and over and over and over. So is that a law?
The PPCC is the law that should be upheld. It is a law on the Liberian. Listen. It's a law on the Liberian law.
You say why they're not upholding it until it comes to Finda Bundoo?
That's what I'm saying. So you don't know the trend of the government, the current government. I'm not supporting the government here, right? The current government, probably they have started a process that we all need to watch out and see how far they will go. I have my personal bit with
the public work minister went before the Senate. He didn't observe the PPCC law or other laws when it comes to awarding contract. He said he was sorry. They say, okay, it's okay. Right? So that's why
I agree with him. The Liberians themselves, they have a stake in the governance process. Let's assume some Liberians do have pieces of evidence to prove contrary from what a certain legislature has done. They have a right to petition. They have a right to move the court. They have a right to take other actions. But we can't sit here on this matter. This is a specific issue that we came to discuss. Now, with Finda Bundoo, she's not somebody that I'm saying here to say she's guilty, she's not guilty. We all are looking at the case as it is. And we all have said on this platform that the trial, we always sit and watch how this trial will go. Now, before
what is your legal opinion? You think it's going somewhere?
Before legal opinion, I want to provide some piece of information for my colleague here, Consider Atty. Freeman, because he said that conflict of interest, there's no law on the Liberian law, and I want to provide some piece of information and for our listeners that indeed there are laws on the Liberia as far as conflict of interest is concerned. Liberian laws, 1986 Constitution, Article 90A, it prohibits public officials from engaging in activities that are against public policy or constitute a conflict of interest. One, 2, Article 90C gave the national legislature, 90C of the Constitution gave the national legislature to establish a law on the issue of conflict of interest. And based on that, the Code of Conduct, the National Code of Conduct that was established in 2014, Section 9.1 defines conflict of interest. 9.6 requires officials to recuse themselves from decisions where conflict exists. 14.1 outline penalties, including dismissal, removal, disqualification from holding public offices in Liberia. So that is just to provide a piece of information that indeed conflict of interest do exist under Liberian law.
Right. So the Code of Conduct talk about conflict of interest. Anthony Freeman, what's your?
I said we are discussing criminal law. I said that there is no criminal statute. The Code of Conduct is a. Mama, give it a chance. You already made your point. The Code of Conduct is an administrative statute. For there to be a criminal statute, Dennis, it must prohibit a conduct. It must establish the elements of that conduct. It must establish the penalty for that conduct. It has to be prescribed that if you commit this crime, this is the penalty that you will follow you. That is not in the Code of Conduct. The Code of Conduct is a broad administrative document that just tell you you shouldn't do conflict of interest and all of that. But if it were in the penal law, it will tell you this constitute conflict of interest. If you do it, give me chance.
Interjection.
When you do it, we will punish you. Give me chance. Give me chance. When we do it, we'll punish you by jailing you, by fining you, or a combination of the two. We don't have that under Liberian penal statute. I was very specific. Criminal statute. I'm not talking about administrative law.
Okay, and I provide that for you. Abuse of office, subsection E, the Liberian penal law, misuse of public positions for personal gain. Economic sabotage, subsection F, include fraudulent procurement, misapplication of entrusted property, insider dealing, bribery and intimidation. All of those are under the
So you have conflict of interest in our list?
That's what it's saying here.
You still have conflict of interest on our list? Are you reading?
Listen.
Look, my man, we're discussing law. You read anything in our list so-called conflict of interest as a criminal act?
Conflict of interest is defined. What is conflict of interest?
In the criminal statute that you just read, is there?
Yes, it's there. They are public office. Based on your public office.
No, it must be specific. It must be specific. This is criminal law. It has to be specific.
Misuse of public office.
No, Daniel, we're not coming to discuss legal philosophy here. We are discussing practical law.
I want to hear Jayweh or Councillor Jayweh's opinion on this.
You know, what is interesting is that the provision read by Attorney Jensen from the Constitution speaks administratively. And so that those provisions standing alone will not constitute a crime, because it does not define what a crime is, it does not define the penalty, and so forth. But
even the Code of Conduct that prescribe the penalty.
When a government official, like in the case of Ms. Finda Bundoo, is alleged to use her office to loot government coffers, use government money, if you can connect that to theft of property, which is misuse of public property, to what he just read, then standing is clearly in the statute, it says you will not find conflict of interest and defined as a law with a penalty. But if your actual result
use of public office.
Yeah, but if you use your office for the purpose of committing a crime, that law would be in conjunction with the theft of property law, be binding on you as a criminal, and you can be convicted at the end of the day. But what I wanted to say I wanted to speak a little bit to the last caller who say, when somebody slaps somebody, then you see like when lawyer, the person was defending in the big case, then he went and run behind that person who they slapped. That person understands nothing about Liberian legal profession. Liberia, people who study law in Liberia study general law. Right. So you can study criminal law, constitutional law, administrative law, labor law, and all the other laws. You can defend depending upon what you are comfortable with. You can decide that I want to become a criminal lawyer and a civil, I want to participate in criminal cases and constitutional cases. Or I want to practice all of it. When you come to the United States or Europe or anywhere else you go and decide to say, I will specialize in criminal, like Attorney Freeman is a financial aspect. If he decides, say, I want to specialize in financial crimes, then he will get a master in that area. So if he wants to, he can continue to just pursue that area. But Liberian lawyers have the right to represent anybody, no matter how big the case is, no matter how small the case is. But it depends upon the individual to decide whether you want to represent someone who, that's what happened in Liberia. We have
Councillor Jayweh, we got to close in the next 5 minutes.
Yeah,
so I want us to close with this one, right? Mm-hmm. Because I know sometimes people say, "Oh, the laws are on the books. The laws are on the books." but we know that, and Attorney Freeman raised that. So my question to you that I want us to close: what reforms could strengthen Liberia's ability to detect and prosecute the kind of crimes we're talking about tonight? It could be money laundering, theft of property, conflict of interest, and all the different things. What reforms are necessary?
So there are laws for theft of property in the penal code. Mm-hmm. The penalty is defined. The penalties are defined. There are laws for money laundering in the penal code. What Attorney Freeman is referring to are not specifically there stated and defined. What the penalty defined would be something like what do you call it?
Conflict of interest.
Conflict of interest.
No, let me rephrase my question. I wonder the law, because we have seen a lot of time people who even we know they steal, they go to court, they're free. Mm-hmm. So what are some of the reforms to strengthen our law so that these kind of cases will be prosecuted and people will be convicted?
You said there are some cases that people go to court and they are set free?
Yeah. They win the case because
that's part of the justice system.
The objective of the justice is not to convict. The objective of justice is to make sure that justice is done. Mm-hmm. So if you took a group of people, like 40 people or 42 people, they're taking the court now, the burden of proof rests on the state. Right. If the state cannot ensure that a chain that connecting all of these 42 people lead to theft of property, and everything falls apart, those people, there's a doubt created that they are all allowed to go free. Doesn't mean that they did not commit a crime, but because the prosecutorial arm of the government did not properly charge as they should have charged, or did not prosecute the case as a prosecutor, so they go free. Now, if you're talking about reform, I would say some of the things that comes up from what I was saying, could be the Liberian reform. I think they got an agency called Liberian Law Reform, right? The Liberian Law Reform can start to look at some of those things and make proposals for definitive, direct actions for those things that may be part of that grows out of financial crimes, but they are not clear. For example, most financial crime will be either prosecuted under theft of property, economic sabotage, and so forth. Misuse of public office and all of that. But I think there could be the criminal law could be reviewed to see what are the lapses that are there that could be clearly defined. Maybe bringing financial aspect. People who have seen, like Attorney Freeman said at LACC, there were times that they saw that people had illicit property that they enriched themselves, but there existed no law to be able to charge them. I would have charged them because it could lead up to theft of property. Instead of saying, oh, we will not charge them. But I think if you are definitive in defining those crimes, and the punishment will be a proper thing to do.
Thank you. Attorney Jensen, your reform. We're talking about solution here. And
Well,
I'm
reform-
giving you every 1 minute because we have to close.
Okay, I agree. I don't want to talk long. I'll talk
He
long.
want to educate me.
Yeah, I have to, because you need to know that there are laws on the board. Here's the issue. Liberia has so much laws. And I think the problem too, why we do not want to be here to criticize lawyers, the primary thing that we lawyers need to do is to do thorough research.
Correct.
The laws are there. Our failure, our laziness results to coming public and not knowing the law controlling. Under the circumstances, it appears there's no law. So you see, what I demonstrated here tonight is to tell you that, look, the issues are bad. We must clearly know how to define our own issues, find the laws, and be able to make analysis, argument, and make a recommendation or reach a conclusion. Convince the court, the judge. So relatively, we have laws in Liberia that address most of these issues. Yeah.
Thank you. Freeman, you're 1 minute.
Okay, Dennis, I haven't come here to support Finda Bundoo or CDC or anybody. We just came here to provide some clarity to a legal issue that is happening in Liberia, for which the Liberian people, if they get some like professional debate, will have some idea on the issue. My position on this case is summed up in the example that Dennis gave. Cllr Martin has a tendency to write fancy things on paper and go to court and not proving. He did it with NEC. Went to court on insider trading. The judge dismissed the case. That no insider trading exists under Liberian law. That is my position. What they got wrote in that indictment points to a crime, illicit enrichment. But we don't have illicit enrichment under Liberian law. So I'm saying my professional view is that it's likely to be thrown out, just like the way the case against the woman from NEC, Deviata Brown Lasana, just like the Deviata Brown Lasana case was thrown out, it will get thrown out. Maybe I may be wrong. I came on this case because I want to highlight those reforms that are necessary. Illicit enrichment, we need a law for it. We need a law not to go around beating around the bush for all to know what conflict of interest is. Write a law, be specific, and say this is conflict of interest. If you do it, you'll go to jail for 5 years. We'll fine you $1,000, $50,000. Write it down in the criminal statute, so you don't have to be going around beating around the bush. So that's what I'm saying. Conflict of interest, illicit enrichment, laws for protecting. Those are things. That's why I'm on the show, to highlight that those things are missing in our criminal statute, and we need to do it to correct it.
Thank you. On that note, we're going to close with our song that says, "We are all."